Hi, I'm David Chapman. I'm a professor at the University of Central Oklahoma teaching real estate. I am going to talk to you today about legal documents. As a part of the real estate investment process, it is important that we understand three different legal documents fairly well. The first one is the deed, the second one is the earnest money contract, and the third one is the commercial lease or the lease. So we're going to start off and talk about the deed. And it's fitting that we would just give a definition of the deed right up front. A deed is a written instrument by which a property owner or a grantor conveys to a grantee an ownership interest in real property. Again, a deed is a written instrument. By the statute of frauds, it has to be in writing. Property owner as a grantor, so the person conveying the property is the grantor, conveying to the grantee, the person receiving the property, an ownership interest in real property. Okay, so that's the definition of deed. We have several different types of deed depending on the quantity and quality of what's being conveyed. Just briefly, we have a warranty deed, a bargain and sale deed, a quitclaim deed, QUIT claim deed, a gift deed, executor's deed, sheriff's deed, and a deed in trust. So there are many different types of deeds. The most common one you're going to see is a general warranty deed or a special warranty deed. And we'll talk about those again in a minute. So there are some essential elements that are necessary in order to have a legal deed. And I just want to go through those briefly. The first one is you have to identify the grantor. We already defined the grantor a moment ago. Likewise, you have to define the grantee, and we talked about who that is. The third one we haven't talked about yet, and that is consideration. A consideration is some type of valuable consideration given for the transaction. Generally, this is money, but does not have to be. So it could be a nominal amount of $10 or something like that, but or it could be love and affection. It could be a lot of different things that are considered valuable that can be what we consider consideration. Now, don't mistake this for earnest money. This is not earnest money. This is consideration in the deed. Then we have what's called words of conveyance that are essential elements. Words of conveyance say something like, I hereby grant and convey. Okay, so it's very clear what you're doing and the purpose, okay, in the deed. The next one is legal description. Understand that the legal description cannot be an address. Legal description has to be just that, a legal description, which is defined as one of three types of descriptions. One of them is meets and bounds. The second one is rectangular survey. And then the third one is lot and block. Probably 90% of the time you're going to see lot and block unless you're doing land. Then you probably or might see rectangular survey and maybe even meets and bound. But those are the legal descriptions required on the deed. The next one is signature. Now, this is a little strange because only the grantor must sign the deed. So the person that is conveying the property has to sign the deed. Understand that the grantee, the person receiving the deed or the ownership being conveyed to, does not have to sign the deed. Okay? Also, it's a little different in that there is no required date on a deed, which I've always thought to be very strange that we don't put a date on a deed. So that's why it's really, really, really important to file the deed or record the deed at the county assessor's office to give you a timestamp on when that deed actually took place. So the last thing is that you need as an essential element, because date isn't necessary, you need delivery. And you need proof of acceptance is the last thing that has to take place. Proof of acceptance in the delivery of the deed. That generally takes place at a title company because then you have a closer, an escrow agent there that is a notary public that can actually witness that acceptance of the deed. Okay, so those are the essential elements that are needed in a deed. and those are and the types of deeds. Again, the general warranty deed is the best type of deed, and that gives you all of the covenants and warranties that we talk about, and that's the best type. Then you have a special warranty deed. It will have all of the covenants and warranties, with the exception that only those covenants and warranties are guaranteed during the time that that owner owned the property. Okay? Then you have the rest of the deeds, whether it's a bargain sale deed, a quitclaim deed, a gift deed, a sheriff's deed, whatever deed it is, will not have all the covenants and warranties. Okay? So they're just not as high a quality of deed as the rest of the deeds. A quitclaim deed is the other one I'll talk about. A quitclaim deed has no covenants and warranties. The only thing that you're telling the new owner is that you're going to get all the rights that I have, without even defining those and giving any assurances or any promises associated with that. Okay, so that's just a general statement about deeds. And now we're going to talk about earnest money contracts. And who are the parties to the earnest money contract? Well, the parties are the buyer and the seller. We're going to be the parties. We'll have consideration here again. Consideration or the purchase price should be described in the proper detail. Then there will also be a survey and meets and bounds description in the earnest money contract. Now, when we do the description of the property here, we will also probably use an address if there is one, and then we'll also give it a legal description as well. And we'll do that with a survey. Okay, we'll have a survey performed in one of those methods of property, and so that's where it will come from. We will talk about the financing conditions as to the purchase of the property, how much is being put down, what type of loan, and then we may even require proof of monies available for closing as a part of the financing conditions. The next one we have is earnest money. Earnest money is not required as an essential element of a contract. We recommend it. It's a good idea. It just shows good faith and an earnest desire to complete the transaction. Earnest money. It's not regulated by the state as to how much. It's negotiable between the buyer and the seller. Okay, so that's earnest money. Property inspections. There's almost always in any contract some provision for property inspection, even if it is as is. And the definition of as is basically that the seller is not expected to perform any repairs associated with the transaction. But typically what you'll say if that's the case then is that the buyer understands that they are receiving the property as is. However, at the buyer's expense, they are having an inspection, and then the transaction is contingent upon the results of that inspection. Something like that is prudent when it comes to property inspections in the contract. The next one is environmental assessments. You will ask for any previous assessments environmentally that have been accomplished, maybe a phase 1 or more, phase 2, 3. But at least you're going to give the provisions to do a phase 1 as a part of the contract. And you need to make sure that the time frames in your contract are significant enough so that you can accomplish that that assessment, which might take a little time to get set up. Title exceptions. The title exceptions need to be researched and dealt with, so there needs to be time. Once you turn in that contract to a title company, then there needs to be time built into the contract for them to research and make sure that there are no title issues. And then if in the contract you'll leave a certain amount of time for the provision that if there is some sort of title exceptions, you'll have some time to go through it and remedy those things. Okay, we have compliance with regulations also that we need to discuss a little bit. All the government regulations, zoning ordinances, building codes, sanitation laws, flood controls, all of those things in the contract need to be addressed in some way that gives you time and due diligence in ensuring that you have complied with all the things. For instance, you may be buying a piece of land that's going to require a variance from a city council or a planning group. And so if you do, then you need to put time and a contingency upon your proper zoning for what it is you want to accomplish. Okay. Also, if you're looking at a commercial contract, then there are things like assessments you need to make sure of that are paid, or if there are any, they need to be defined. Crossover easements, curb cuts, and things like that with other groups. I've actually had to give, when selling something, I had to give easements to things, to sewer lines and water lines and things like that over to new owners. So we need to make sure that there are easements given that are necessary with the transaction. Another thing that's important whenever you buy something with the contract commercially is an estoppel letter to the tenants. So what this letter would be was you get a rent roll, and then all of the tenants would write a letter to the owner stating that they understand the lease and the lease expiration and how much is paid, and that nothing has been verbally promised to them. And so it's very clear, and there's proof to the new owner that everything that's in the lease is appropriate and has stood with the tenants. And then you want to review all the leases to make sure that you can actually live with all the terms and conditions on those leases, because those leases will transfer to the new owner. Another thing in a commercial contract, you want to give time and ask for all income and expense statements and reports. You want to be able to go through the financials and see how the expenses affect the property NOI, and make sure that financially it's just the due diligence period that you can do. Make sure that you're able to get and that you can afford the insurance coverage as a part of your pro forma. So you'll put time in there and maybe ask for information that pertains to insurance coverage. And then review of maintenance contracts. If there are existing contracts out there for maintenance, lawn care, things like that, you'll want to review those and see if you want to continue those, and see if there are provisions for you to exit those agreements if you do not. So just understanding all the issues that are accomplished, and then making sure that you're able to put those into the contract to make you feel comfortable during due diligence when you're buying the property. Okay.